like to thank everyone for attending this evening. Obviously, we are attending via Zoom, and so while Zoom is a great way to connect, I do not like doing presentations via Zoom. So let's hope for a vaccine or some good therapeutics for this virus, so we can all come together again. I miss seeing all your faces. I miss the energy that you guys provide. So hopefully you'll still get a lot out of this presentation, although we're not in the same room together. So the 5 most important concerns for HOAs right now. Well, normally when I do this class, it is during this time of the year, and I'm looking forward to some of the legal issues that may affect our lives in regards to HOAs for the next year. And I'm looking at some of the big topics from the previous year and going over them. This year obviously is different. For example, the Arizona legislative session was cut in half. So we really didn't have any new legislative changes worth noting. The court system has been severely hobbled, and it hasn't been able to effectively get through its docket. So normally we would have some cases that we would discuss. We don't have that. What we do have is the COVID-19 and the myriad of issues that COVID-19 has brought, not only to our society at large, but to our community associations. We also have one ballot initiative, believe it or not, that could have a very impactful effect on community associations, and that's the potential legalization of personal use marijuana. If that ballot initiative passes this November, personal use marijuana usage will no longer be legal. And will no longer be illegal. And for those of you who live in condominiums or walk through community association parks and things of that nature, that may affect you greatly. But in the meantime, we're going to address the elephant in the room, and we're going to talk about the COVID-19 pandemic. So obviously, we're going to talk about the COVID-19 related issues. That's probably going to dominate today's conversation. We'll do a brief summary of where we were, where we're at, and hopefully where we're going. Next one, Bruce. Because of the COVID-19 pandemic, there's been a lot of reaction in regards to community association meetings, especially annual meetings. This is, we're coming into the time for annual meetings in community associations. Our winter visitors will be returning soon, and with their return is many annual meetings will take place. And if the current COVID-19 protocols remain in place, those meetings can't occur. So we will talk about some alternatives and how to address annual meetings in the COVID-19 era. Next one. Now, we're also going to talk about COVID-19 as it involves insurance. Namely, we're going to discuss the question, is a community association covered for COVID-related claims and damages? The biggest one you may have heard so far is, as you know, well, some of them just reopened actually, but a number of community associations closed their pools, tennis courts, and gyms. And there's been litigation on a nationwide scale regarding homeowners filing suits against those HOAs for basically an uncompensated taking. What do I mean by that? Well, you pay assessments to maintain the pool, the tennis courts, and the gyms, but you can't use the pools, the tennis courts, and the gyms. And so there are some insurance issues related to that we will talk about as well. We'll also discuss some of those HOA-related matters that we have to still, nonetheless, effectuate, even though we're in a COVID-19 scenario, and that involves corporate formalities. And we're going to talk about HOA enforcement issues in light of the COVID-19 pandemic. As Bruce and I were discussing before the presentation, Bruce asked me how my business was going. And I told him business is booming, unfortunately, in the litigation side of the equation. And the reason why is, you know, for the most part, a lot of us have been cooped up in our homes. And so maybe the yard with the weeds in it, you know, when you're going back and forth to soccer practice and home and on vacations and such, the yard with the weeds, you know, you may see it passingly, but you don't fixate on it. But when you're working from home and right outside your window is the yard full of weeds, you tend to fixate on that. And homeowner associations tend to fixate on that. And that creates a lot of litigation, which is even more problematic because of the severe slowdown and delays in the court system because of COVID-19. So we'll talk about that as well. So let's talk about the current state of affairs when it comes to COVID-19 regulations. We in Maricopa County have done well is not an appropriate word because well suggests that you know, we have a proper measuring stick. I will say that in regard to the governmental regulations that have been provided to us as guidance concerning our condition regarding COVID-19, Maricopa County is doing better than most. We're doing better than Coconino County. We're doing better than Pima County and Pinal County, which means that a lot of the HOA-related amenities can now open, which is good news. So pools can open, tennis courts can open with appropriate social distancing. That's going to be the mantra for the next year or so until we come up with adequate therapeutics or a vaccine. You know, the baseline level is going to be social distancing, or as some people, you know, like to say appropriate spacing, but it's the 6 feet rule. You know, make sure you're 6 feet away from other individuals not in your household. So most tennis, you can play tennis 6 feet away from your opponent, so long as you're not playing doubles. You can play doubles if both sides are in the same household. Same with pools. It's been pretty much shown that COVID-19 transmission is difficult in water. So pools have opened up, tennis courts have opened up. Gyms is another matter. Gyms are a little are still in a gray area. The law right now would suggest that gyms can open with appropriate social distancing and with appropriate cleaning protocols, okay? But the problem with many community association gyms are that they're very small. So you can maybe get 1 or 2 people in the gym area if you want to address proper social distancing. And then the wipe down, you know, ensuring that users of equipment adequately wipe down the equipment. Now, early in the pandemic, there was the phenomenon of what I call use at your own risk. So a lot of associations were putting up signs saying, the gym is open, but you use it at your own risk. We're going to go into more detail about that when it comes to the insurance discussion we're going to have. However, use at your own risk does not work when it comes to COVID-19 because of the governor's mandates regarding the use of certain spaces. So you can't say to someone, use the area at your own risk while you in turn violate the judge's orders. So if the judge's, not the judge, my apologies, the governor's order. So if the governor's order says no more than 50 people can congregate in one room, right? You can't allow 70 people in a room and say, enter at your own risk. The governor's mandate is what it is, and community associations are required to follow that mandate. And so the use at your own risk was, again, an attempt to keep these areas open. But unfortunately, as experience is teaching us, that's not effective. COVID-19 and HOA meetings, again, live in-person board meetings can resume so long as the association ensures proper social distancing and everyone wears a mask. That's the rule. So if you can ensure proper and it's under 50 people. So I always forget the under 50 people. Every time I say that, I think of my own association where while I was on the board, we were lucky to get 5-6 people show up at those meetings. But it still has to be under 50 people. So if you'd like to hold live action board meetings, make sure everyone's socially distanced, make sure everyone's wearing a mask, and make sure you have less than 50 people in there. If you can do that, then you can hold your meeting in person. If you can't do that, then you'll still have to conduct your meetings via Zoom. When it comes to annual meetings, we're going to talk about that in great detail. That's one of the items we're going to discuss. And obviously, if you have a small annual meeting that has less than 50 people and you can adequately social distance and everyone is wearing a mask, you can hold the annual meeting in person. If you cannot ensure those requirements, then it's going to require that annual meetings be held differently, and I'll give you some suggestions on how to accomplish that. HOA common areas, we already discussed that. Most HOA common areas should be open so long as social distancing and masks are used. Fitness centers, again, can be open or they may be closed. It depends on whether social distancing can be observed and the equipment can be cleaned off regularly. Finally, when it comes to COVID-19 and HOA assessment, collection, and enforcement, the pandemic does not alleviate the association's requirement to collect assessments or to enforce restrictions. I'll say it again. The pandemic does not alleviate an association's requirement to collect its assessments or to enforce its restrictions. So there were a lot of associations in the beginning of the pandemic when there were high numbers of unemployment and people were staying at home. We really couldn't do anything because the maximum level of restrictions were in place. A lot of associations were saying, hey, we can't even meet, so we really can't enforce the association restrictions or collect assessments. Now that we do have more freedom, there is the requirement is that associations enforce their restrictions and collect their assessments. So let's talk about annual meetings in light of the COVID-19 pandemic. The COVID-19 pandemic does not alleviate the association's requirement to hold an annual meeting. Okay? The pandemic does not alleviate a homeowners association's requirement to hold an annual meeting. Pursuant to the Nonprofit Corporations Act, if your HOA is a nonprofit corporation, you must hold an annual meeting at least once a year, but no less than 15 months after the previous annual meeting. So we have to hold these annual meetings. And we can postpone them up to 3 months from the last year's annual meeting, but we have to hold them pandemic or not. Pandemic or not. So what does that mean exactly? So what that means is we got to hold an annual meeting. And we have to figure out a way to do so within the bounds of the restrictions regarding COVID-19. Now, again, the 3 restrictions we have to concern ourselves with is proper social distancing with the requirement to wear a mask, and you cannot hold a meeting with 50 people or more. And so if you're so the 50 people or more requirement is really the line of demarcation. If you consistently have 50 people or more attending your annual meetings, then the possibility is you're going to have to hold your annual meeting via Zoom, because you can't have more than 50 people in a room. It's doubtful that anyone's going to rent you a room where you can put 50 people or more. And moreover, the enter at your own risk does not apply because this is a governmental order. Okay, so if you're going to have more than 50 or 50 or more people at your annual meeting, you're going to have to do it via Zoom, and we can provide some thoughts on that. If you're going to have less than 50 people at your annual meeting, then social distancing and masking, if you can ensure that, then you can hold the annual meeting in person. The reason why this is important is because you're going to have to figure out how you're going to provide notice of your annual meeting. Are you going to let people know that the annual meeting will be in person? Or are you going to inform people that the annual meeting will be held via Zoom? You have to make this decision very quickly, especially if you're looking at a November, December, January, February annual meeting. You're going to have to make that decision quickly because you have to make the people aware. Question from Mr. David Raber. Does the 50-person max apply for an annual meeting if the meeting is held outdoors? No, it does not. But you have to adequately social distance, and everyone has to wear a mask. Okay? So if you can find an area, right, that's large enough to keep people 6 feet away from each other, having more than 50 people. I sound like one of my 13-year-old's algebra tests here. If a train leaves from Chicago at 5 p.m. and LA at 4 p.m., if you can have an area where you can socially distance more than 50 people, so they have to be 6 feet apart, and everyone's in a mask, and people can hear you, then yes, you can do it outside. That would require a massive area, pretty large area, and it's going to require sound amplification, because that's a pretty big area. That's a large area indeed. So you're going to have to figure out how you're going to handle it, and that's going to be in your annual meeting notice. And remember, there are requirements for the amount of time that you must provide for annual meetings. Now, I wanted to just ensure that everyone is reminded of the reasons why we have an annual meeting. It's normally to conduct member business, is to elect members of the association's board of directors, if so applicable, and is to allow members to address their association. Now, this is where having a Zoom annual meeting presents potential issues, okay? Because if the purpose of an annual meeting is to allow owners to address their association, i.e. if the purpose of the annual meeting is to allow members to address each other and the board of directors, Zoom is a difficult way of doing that. It just is. We have to be honest about it. We have to type questions in a dialogue box. There's muting, unmuting. It's a challenging way to hold an annual meeting. So one of the suggestions is, if you're going to hold your annual meeting via Zoom, in your annual meeting packet, ask owners to provide any questions that they may have in advance of the meeting, so that what can happen is whomever is the moderator of the meeting will have all the questions that have been pre-submitted, and then those questions can be answered by the appropriate individual at the meeting. So you're not worried about typing in questions or seeing if someone's raising their hands or things of that nature. The questions have already been pre-provided and they can be answered that way. You know what else I don't like about Zoom presentations? I'm actually sitting. And for those of you who have attended my presentations before, I like to move around. And so sitting in a chair, I want to move around. So if I'm moving around a lot on the screen, I apologize. Again, we're making do with what we have. So another challenge with having an annual meeting via Zoom is voting, okay? In Arizona, votes are cast via mail ballot. Votes are cast via mail ballot. And so this is a situation where when you're sending out your annual meeting mail ballots, you want to provide the owner with as many ways to return that mail ballot to you as possible, especially if you're going to have a Zoom meeting. Because remember, if we're having this, when we have our normal annual meetings, you know, some owners are arriving at a place. So some owners will put their ballots in the mail, but some owners actually get in their cars, they drive to an auditorium, and they'll cast their ballot at that auditorium. We can't do that in a Zoom meeting, right? So all the ballots have to be provided to the association before the Zoom meeting, unless you're providing creative ways to return your ballot. So for example, you can allow your ballots. Now, of course, all of these examples are for non-secret ballots, okay? If you have a secret ballot, there's only three ways to return a secret ballot. Only three, that's it, only three, okay? One, you mail it. Two, you drop it off somewhere, right? Or three, you give it to someone. So one, you mail your secret ballot in the envelopes as provided. Two, you get in your car and you drive over to the management company's office and you drop it off there. Or three, the board president, you can elect to give it to the board president in the secret envelopes and such. That's it. That's it. So all of these suggestions are for non-secret ballot elections. So if you want to have a Zoom election, you can allow the ballots to be returned to you via email. So someone is sitting at their desk, just like I am in my office back here. And by the way, this background, it's a background, but it really is my office. When we moved into these offices, wow, yikes. 14 years ago, we moved into these offices. We've been here a while. No, that's not. Yeah, 14 years ago. Wow, time flies. That was back in the day where law firms had legal books. And we actually referred to legal books. Now all of our legal research is done online. But we bought some legal books back there. Those are full of cases. And I put them in my office. And so I thought that instead, you need to have a background if you're going to do these Zoom calls. So I just took a picture of my office and put it on the Zoom call. I get a lot of flack for that, though, because they say, well, even Bruce said, wow, that's a very lawyerly background you have there. And I say, well, Bruce, that's my office. But anyway, so you can have someone at the office in real time, receiving email ballots and counting them. So that is a way that you can hold your Zoom meeting and still accept ballots in real time. Ballots can be faxed back. Ballots can be mailed back. All you have to do, however, is you have to ensure that the mode of transmittal is on the ballot. So if you're going to allow the ballots be emailed back, you can simply put the email address on the ballot, and that will work. So we have a question from Matt Ketchy, and if I said that wrong, please forgive me. How do social distancing rules apply to spas' hot tubs? Is the 6-foot rule still relevant, or should the spa be closed altogether? our spa is small. Only 2 people could adhere to the 6-foot rule. Well, then only 2 people can be in your spa at any given time. While most scientists agree that COVID-19 is not easily transmitted in water, in a spa, you know, half of you is in the water, the other half is out of the water, and you're talking to one another. And scientists agree that one of the ways to catch COVID-19 is through the exchange of conversation. That's why we're all wearing masks. So I guess if there's 2 people in a spa, or you want more than 2 people in a spa because you can't socially distance, you could wear a mask. Now that kind of defeats the social purpose of being in a spa. But suffice it to say, if you cannot socially distance in the spa, then you know the spa must be limited to the amount of people that can use the spa at adequately social distance. Okay, so again, back to absentee ballots. Make sure that the mode of receipt is on the ballots, and you can allow ballots, non-secret ballots, to be transmitted via email. Now, again, ballots have to be signed if they're not secret, right? So I get a lot of questions. Well, Augustus, if someone is emailing a ballot, how do you authenticate it? Well, the authentication of the ballot is the signature at the bottom of it. This is a non-secret ballot election. So you'll be signing your ballot, and you authenticate that email ballot through the signature on the ballot. Another way to effectuate elections in the COVID-19 era is to have an online election where you can hire several companies and they will actually take care of the voting on the computer, online. I have several very large homeowner associations that subscribe to this, where an owner will basically, the company will come in, work with the manager, work with the attorney to make sure all the legal requirements are met, and the individual owner will be mailed an individual login and an individual password. You'll go online, you'll enter that individual login, you'll enter that individual password, and you'll be given the opportunity to vote. The online company ensures security. They ensure the counting, the accuracy. It's a pretty good system. Some of my clients have been using it for 4 or 5 years, and it works well for them. It is expensive. It is expensive, but it is an option out there. We have a question from Joan Grimm. How do you suggest ballots be counted? I'm assuming the real question is, if you're going to allow ballots to be received via email, and you're having a Zoom meeting, how are you going to count the ballots? What's the suggested method of counting the ballots? And this does create a challenge, because normally when I'm doing an annual meeting, I will, when I'm conducting one, I'll have a counting committee. I'll pick 3 people from the audience, 3 random people from the audience, and those will be the people that will actually count the ballots. Well, if we're in a Zoom scenario, obviously we can't do that because we're all, you know, together via the miracle of electrons and signals and such. And so associations are going to have to place the counting of a ballot with someone that they trust. Their professional manager, their attorney, maybe a member of the board, but a singular individual is going to have to be responsible for the counting of those ballots and the certifying of the election results. So how would I suggest counting the ballots? In a Zoom scenario, you just make someone accountable for receiving all the ballots, either via email or fax or mail or however they're going to be returned to you. And then that person counts them and swears and attests to the results of the election. That's what we're forced to do if we use a Zoom scenario. How expensive is the online voting system? It depends on, they charge you per door, okay? So some of my larger clients with 2,000 to 5,000 doors, They pay an upfront cost of $3,000 to set it up. And then it's a cost per door. And it's not a cost per vote, it's a literal cost per door. If you'd like some more information on that, I will be doing a presentation in December on that, and there'll be some information on my website. Or you can reach out to Mary, M-A-R-Y, Mary, at shawlines.com, and we can give you a couple of the companies that we've worked with in the past. Just because we're holding the annual meeting via Zoom doesn't mean that we get to skip the formalities. So we still have to create an annual meeting agenda per statutory law. The Planned Communities Act and Condominium Act says that an agenda must be provided before you call the meeting to order. Now, there you go. Now we have a challenge, don't we? Well, how can you provide the agenda before we call the meeting to order if everyone is attending via Zoom? Well, that means that you're going to have to send the agenda out early. You're going to have to send the agenda out early. So you're most likely going to have to send the agenda for the annual meeting out with the annual meeting notice. Some associations already do this. Some associations will wait until the actual meeting and then they'll provide an agenda. Well, if you're going to have a meeting via Zoom, that agenda has to be sent out before the Zoom meeting in order to meet the requirements of the law. The next problem with Zoom meetings is ratifying the previous year's annual meeting minutes. That's something that's normally done in the in-person meeting, right? Well, we're not having an in-person meeting. So this is something that must be done prior to the Zoom meeting. So what you can do is you can add a spot on your mail ballot or send out a separate ballot where owners will vote to approve the previous year's annual meeting minutes. Of course, you'll have to submit the previous year's annual meeting minutes in the packet and hope that there aren't any changes. But again, we're in challenging times. And again, do not restrict the participation of members at the annual meeting. Although Zoom is inherently restrictive, if you can tell owners, hey, if you have a question that you'd like to provide before the Zoom meeting, please do so. At the very least, provide the ability for questions to be posed in the chat box. We still want to try and give as much access as we can to members. Okay, so insurance. I have received just so many questions about COVID-19 and insurance, such as, if someone were to sue us because they got COVID and we were not following the governor's proclamations, what's our liability, first? And second, can we tender that to our insurance carriers, right? What happens if we close down the facilities out of an abundance of caution? If an owner were to sue us saying that you've breached your contract with me by not making the common areas available to me as required by the CC&Rs, what's our liability, and can we tender that to our insurance carrier, right? If someone claims they got COVID from the annual meeting, what's our liability, and can we tender that to our insurance carrier? I've gotten so many questions regarding that, regarding those issues. And so from a baseline standpoint, I'd like to say that at this point in our scientific knowledge, it still is rather difficult to pinpoint how someone got COVID. You can look at the example of President Trump and his COVID diagnosis. He's the most powerful man in the world, and they kind of think where he got COVID, but they don't know where he got COVID. And he's the most powerful man in the world. He doesn't have it now because he has the best doctors in the world. But take that to our level, right? if you and I, just normal, average, everyday people that are living our lives, how are we going to prove that we got COVID in a particular instance? I guess you could say that the only place I have been outside of my house is the association's meeting, and I live alone, and no one has come to visit me, and every single surface that comes into my house, I adequately disinfect immediately before I touch it, and that's how I got COVID. Maybe, but not likely. So I say that to just highlight the fact that from a legal standpoint, it's going to be pretty difficult for someone to prove that they got COVID at an association pool or in an association meeting, okay? But that's not what they're going to prove. What they're going to prove is that the association failed to abide by the requisite governmental regulations, which endangered me, and that's how I got COVID. So it turns the question on its head. It's not I got COVID from the association's meeting. Is the question now becomes the association didn't adequately protect me from COVID at its meeting because the association did not follow the governmental requirements or did not make a good faith effort to protect its members. Remember, especially for those friends attending that are on the board of directors, every member of a board of directors has a duty of care to the members. You must, in good faith, protect the members. Not an option, that's a requirement. And failure to protect the members is a breach of your fiduciary duty. Okay? So if you say, well, the governor says that we're supposed to be wearing masks and we're supposed to be 6 feet apart in order to hold a board meeting, but you know what? We're an association in Apache County. We're all neighbors. We live out in the middle of nowhere. There's no one around us. We're all retired. None of us have COVID, so we're going to ignore that. Just come on to the meeting. Don't worry about masks, and we're all going to sit together, and we're all going to have a good time, right? Let's say that someone who attended that meeting went to Los Angeles the next day and was sneezed on by someone with COVID. That person could say that the association's lack of following the governmental protocols failed to protect me, and therefore the association is liable for the damages resulting from my illness. That is something that someone could allege. Now, will the association's insurance company cover that? Well, let's discuss the types of insurance that associations should have. From a starting point, an association should have every type of insurance that's required pursuant to a CC&Rs. Most CC&Rs will require some type of liability insurance and directors and officers insurance. If you're in a condominium, the Condominium Act has specific requirements regarding insurance in the Act. And I give you the section there, 33-1253. Any association here that has insurance should have a letter from whomever you bought that insurance from. If it's a broker, if it's an agent, you should have a letter or an email that says the policy that you have purchased is in line with the association CC&Rs and the Condominium Act if you are a condominium. Your broker or whomever you bought that policy from should give you a letter saying the insurance that you bought is in line with your CC&Rs, and if you are a condominium, in line with the Condominium Act. Okay? Most associations are up for renewal right now. This seems to be the international renewal period, the next three months or so. You want to make sure that you have that letter or email and ask your broker, ask your agent, hey, the insurance that you're selling me, Is COVID-related issues covered? They'll say yes or they'll say no. Either way, you'll know. They may say no insurance is covering COVID-related issues. And if they say that, you say, great, thank you. Send me an email about what you just said. And then you put that email in your file, and then you go on about your business. But you want to ask these questions, and you want to receive the answers to these questions in writing. So the question says, this class was supposed to be 5 important things an HOA should consider. It didn't advertise that this was all going to be related to COVID. So the answer to that question is, these are the most 5 important issues that an association will be facing over the next 6 to 18 months. All of these COVID-related issues. These COVID-related issues will dominate the association landscape. My firm didn't shut down 1 iota, nor did we take any time off during the past 7 months because of all of these COVID-related questions we've had and the solutions that we've been drafting and crafting to solve these issues. So yes, the class was called the top 5 issues that HOAs are facing now. And the 5 issues, unfortunately, all of them are, the class was called the 5 most important concerns for HOAs right now. Those 5 most important concerns: COVID regulation and how associations should respond to COVID regulation from a governmental aspect. We've been talking about that. 2, association annual meetings. How is an association going to hold its annual meeting in light of the COVID-19 pandemic, in light of governmental regulations concerning the COVID-19 pandemic, and in light of the board's duty to protect members of the association? 3, I'm already seeing lawsuits regarding COVID-19 related failures, either to follow government regulations, or people catching COVID on government properties, or the failure of an HOA to open common areas due to COVID restrictions. You're going to be seeing that. And the 4th thing, which we're talking about right now, is when you do face these issues and the litigation does come your way, are you going to pay your insurance, your HOA attorney, me, 30 or 40 grand to defend you? Or are you going to pay your insurance deductible 5, 10 grand and have your insurance company pay for your defense? Okay. These are all questions that you will be facing in the next 6 to 18 months. You're going to have an annual meeting if you hadn't already had one during the COVID-19 scenario. And even if you had a meeting during the COVID-19 scenario in March, April, or May, you're going to have another one next March, April, or May. And unless we have an adequate vaccine or other therapeutics, I don't see any of these government regulations being absolved. You know, we have an election coming up, and we have 2 diametrically opposed ways to deal with COVID from the various candidates. We don't know which one of those ways is going to prevail. And so we want to be prepared as homeowner associations to be able to adapt to all of the changing landscapes in regards to what's going to be asked of us in the future. So while I do understand the concept of, hey, Augustus, you know, I thought we were going to be talking about other things. We're talking about COVID. Unfortunately, COVID is what we've been talking about for the past 6 months. And COVID is what we're going to be talking about for the next 6 to 18 months. It's the unfortunate reality of our lives. Another question: while we have the insurance you list, we are considering an umbrella policy as well. Any comment or advice about adding umbrella coverage? If you can, add it. If you can, add it. And what I mean by if you can, if it's available to you and you can afford it, right? If it's available to you and you can afford it, Get it. Get it. Remember, homeowner associations, the vast majority that I represent at least, are nonprofit corporations. You are a corporation, and corporations have as much insurance as they can practically have. Why? Because you want to spread out the liability. If you have an insurance policy and an umbrella policy, and the mother of all lawsuits hit, and I can give you an example of that. What happens if my son, who, you know, it's funny. A lot of you, as I told these classes through the years, I would brag about my son, the golfer. When he was young, he was a great golfer. Now he's 15 years old. He's figured out girls, and he's figured out going away to college. And his golf game is not so hot, but he's a smart kid, so I can't give him any grief for that. But let's say that he wasn't. Let's say he kept that golf going, and he was going to receive a scholarship to Stanford, and he's walking through the common area, and there's an exposed sprinkler head that the neighbor across the street has been telling the association, hey, there's a sprinkler head out there. It's exposed. You want to fix it. And the owner's been telling you about that for 5 months, and you don't do anything about it. My son comes through jogging to get exercise and cuts his foot in half because of the exposed sprinkler head. No more golf scholarship to Stanford. That's about $250,000 worth of tuition alone. And let's say he was really good. Maybe he could have gone pro one day. Now, his dad's a lawyer. I'm going to sue the pants out of that association, especially when I find out that someone was warning you about this hazard, so you knew about the hazard and did nothing about it. You're going to get sued. And your $500,000 per occurrence policy or your $1 million per occurrence policy may not cover the star golfer that was all set to go to Stanford. But if you have the umbrella policy then steps in where your normal policy is maxed out and covers you, okay? So if you can afford it and it's practical and the insurance company will offer it, get it. Yes, that is a 1% example. 99% of your lives in HOAs, you will never see that example. 99% of your lives in HOAs, you'll never get sued. But I've been able to sustain a 20-year practice on that 1%. And so has Beth Mulcahy and Carpenter Hazelwood and Maxwell and Morgan and Val Frothingham and Chandler Travis's firm and Brown and Alcott and Buse Gilbert. And then the list goes on and on and on of HOA lawyers that have been able to sustain their practices on that 1%. So as I've been saying, there are 3 types of general insurances: directors and officers liability, casualty, and general liability. If you can get an umbrella, please do. And again, you know, some CC&Rs may require workers' compensation insurance, but don't guess what type of insurance you should have. That is your broker's job. That is your salesman's job. You go to your insurance broker and say, broker, what insurances do I need in order to abide by the CC&Rs, abide by the Condominium Act if you're a condominium, and to be adequately protected? Give me 3 options. Give me 3 options, right? And put that liability on the broker to tell you what you need. Yes, it may be expensive, but do you know it's more expensive? Not being covered when you need to be covered. And the worst thing, one of the things I hate to do with my association clients is them be sued, or let's say that they get a fair housing complaint through the Arizona Attorney General's office. And the Arizona Attorney General's office is going to investigate them. They come to me and they say, Augustus, how much is this investigation going to cost? And I tell them anywhere between $5,000 and $50,000 if you're wrong. And they say, wow, we can't afford that. And I say, well, you don't have much of a choice because it's the Arizona Attorney General's office. Tender to your insurance carrier. And they tender it to their insurance carrier, and their insurance carrier says, you're not covered for administrative actions. Now, what choice do you have? You got to pay a guy like me to defend you. But if you had insurance coverage, you pay a deductible, you let the insurance company hire an attorney, you move on. This is a hot topic outside of COVID. Obviously, you want to ask if you're protected from COVID and COVID-related issues, but insurance is a topic that people take for granted until they're not covered. And when they're not covered, they're asking me, Augustus, who can we blame? Can we blame the manager? Can we blame the board of directors for breach of fiduciary duty for not knowing what coverages they should have? Who can we blame? And so when we're thinking about that, there's an easy way for the manager to not get blamed, for the board to not get blamed, and that is to put the blame on the broker, the guy selling you the insurance. You know, when you go to the car dealer and you say, hey, I need a car, and you tell the car dealer, I need this particular car, and what you need is a nice Astro van, and they sell you a Ferrari, you know, there's a problem there, either with the salesman or with you buying the Ferrari. Well, we can alleviate that now and put that burden on someone else to evaluate what insurances you need. Oh, yes. So, you know, you want to help out your broker. So make sure your broker has all of the documents the broker needs, copy of your CC&Rs, the previous insurance policy. Let them know that you're a condominium if you are a condominium. And if you're a member of a board of directors or a manager, never say, I suggest you take this policy over this policy. Because what you're really saying is, I have evaluated these two policies. I'm an expert in insurance. I suggest that you take this policy as it will adequately protect you. That's what's being heard when you say, I'll go with that company. You're just saying, I don't really know, just go with the cheaper company. What's being heard is, this insurance is going to cover you for all of your needs. So make sure that you always allow those people to make those decisions that are qualified, the brokers and the insurance agents. We're going to go to the last thing that we need to talk about this evening, which is HOA enforcement, which is a hot topic regardless of COVID. Hot topic regardless of COVID. But what makes it more important in light of COVID is a lot of associations are pausing their enforcement. And they're using the rationale of, well, it's COVID, so we should pause our enforcement. No, you should not pause your enforcement. My office, we've been getting a lot of lawsuits against HOAs, right, for not enforcing their CC&Rs. And the rationale is, well, it's COVID. But there's been no governmental alleviation of your requirement to enforce your restrictions. In fact, it's the opposite. As you can see on the screen here, there's Arizona case law that suggests that associations have an obligation to enforce the restrictions. Now, if the governor would have come out and said, and the governor has done this, the governor has said, I'm issuing a moratorium on evictions. You cannot evict someone from their property during the COVID pandemic. Well, that means you can't evict anyone. So if the governor would have come out and said, I'm placing a moratorium on the enforcement of homeowner association restrictive covenants. Now, if the governor would have come out with that moratorium via executive order, you don't have to do it. The governor never said that. So you are still required to enforce your restrictions. You are still required to collect your assessments. You're not required to evict anyone, but you're still required to enforce those restrictions. And you could face liability if your excuse is, well, we're in a pandemic. Unfortunately, that does not alleviate your requirement to enforce the governing documents. And that is a hot issue. And the reason why it's a hot issue is because a lot of associations are saying, Well, we don't want to enforce everything. We want to enforce this aspect of our CC&Rs, but not this aspect of our rules and regulations. Unfortunately, all restrictive covenants, rules, and regulations that are legal and valid must be equally enforced amongst everyone. Next slide. So again, I wanted to briefly go into fines because that is a hot topic in enforcement. So here are the statutes on the screen that discuss an association's ability to impose a fine. Remember, fines must be reasonable, and reasonableness is in the eye of the judge, not you or me for that matter. I can tell you that based on 20 years of practicing law, this is what I think is reasonable, but ultimately only a judge can tell you what's reasonable. But fines must be reasonable. Also, owners must be provided notice of a potential fine and an opportunity to address the board before the fine is imposed. Now we have a COVID issue, or at least we did before we could hold in-person meetings with social distancing and masking. But earlier in the COVID pandemic, fines were being issued, but the ability to be heard regarding those fines was muted because we couldn't meet, right? Now you can meet. Social distancing, wearing a mask. You can provide the owner with the opportunity to discuss the fine before you impose it, okay? So make sure that owners are provided the opportunity to discuss their fines before fines are imposed. Now, as I said, there is no guarantee the fines are reasonable. It's always up to the judge. So this leads to confusion and uncertainty because I may tell you, I think this is reasonable, and then a judge says, no, it's not reasonable. And even if fines are valid, how does an association collect those fines? Under Arizona law, you got to go to court and you got to get a judicial order collecting the fines. Before we get to the next slide, I want to get to this question. Can the opportunity to address a fine be done via correspondence or must it be at an in-person meeting? It must be done via meeting. The opportunity to is in person. So it cannot be done via correspondence. The owner must be provided with notice and an opportunity to be heard. Now, some attorneys take the aggressive stance that an opportunity to be heard is simply write us a letter, okay? I've never had a judge say that that was okay because I've never had an association do that. I've had associations flat out not give an opportunity to be heard via mail or otherwise. And I've had associations actually win lawsuits by giving an in-person opportunity to be heard. So can I say that would the correspondence meet the opportunity to be heard requirement? An argument can be made, yes. Would I advise that? No, I would not. I wouldn't advise that. Fine policy suggestions, escalating fines may be considered unreasonable. So if you violate it the third time, you get a $50 fine. You violate the fourth time, you get 100. You violate the fifth time, you get 150. I actually had a judge recently challenge me, and the judge said, Mr. Shaw, on behalf of your client, can you tell me why there's a $50 difference between the violation that occurred last week and the violation that occurred yesterday? What makes the violation $50 more bad? And obviously I said, the passage of time. And the judge said, but it's the same poorly painted house today as it was 5 days ago, So what additional value, how has the association been harmed? Quantify the difference between $100 today and $150 in 5 days. And the only argument that I could provide was, well, the passage of time and the belligerence of the owner. The judge didn't buy those arguments and reduced the fine amount to the original $50 per violation instead of providing the escalation, okay? Now, why do I tell you that? Because if one judge can do it, another judge can do it. Or, you know, knock on wood, your lawsuit is before the judge who did it the first time. So just understand, I'm not saying get rid of all your escalating fines. What I'm saying is understand that the escalating fine may not be considered reasonable by a judge. And that judge may negate the fine or negate the escalation. Also consider having different fines, different fine amounts for different violations. A trash can violation shouldn't be the same as failure to paint your house. A weed violation shouldn't be the same as parking in the street on a private street, okay? A flag violation shouldn't be the same as having a poodle breeding facility in your backyard. So think about assigning specific fine amounts to specific violations. Courts love that because the crime fits, the time fits the crime, or in this case, the amount of the fine fits the crime. Please have a fine policy regardless. If you want to discuss escalating fines, that's great. If you want to discuss having a fine amount for differing violations, that's great too. But whatever you want to do, whatever you do, have it in writing. Written fine policies are your ticket in the game. Without a written fine policy, your fine is going to be held de facto unreasonable. There was a case called the Turtle Rock case that stood for that proposition. It was decertified by the Court of Appeals. It was unrecorded, which means that it's no longer precedence, but I haven't seen a judge that hasn't followed it. I have yet to run into a judge that has said, if you do not have a written fine policy, your fines are still nonetheless reasonable. Every judge that I've run into, if you don't have a written fine policy, per se, your fines are unreasonable. And that has to do with the notice requirement. Judges want associations to place owners on notice of everything. That includes fines. And those fine policies should be reviewed once a year to make sure that you're within the realms of reasonableness. Quickly, in the HOA tune-up category, don't forget, banks may have differing hours of operation, but don't forget to make sure your statutory agent is up to date. That's still a requirement. Make sure your business address is up to date on the Arizona Corporation Commission website. Update or remove your notice of community association, depending on if you have one recorded. Make sure to file your annual report as required. Make sure the proper information is displayed on the annual report and the statute there is provided. Make sure you have your governing documents readily available. You would be surprised how many HOAs come to me and say, Augustus, we don't have our articles of incorporation. Or Augustus, we've lost our bylaws. That's not acceptable. Make sure that you have all of your governing documents in a form that you can copy, and make sure that your policies and procedures are reviewed by your attorney to ensure that they're still legal. This was the year, outside of COVID-19, the first year in 20 years of practice where the legislature didn't change something for the HOAs. Something important for the HOAs, I should say. First year in 20 years that the legislature didn't change something to where I had to hold a changes in the law seminar. First time. It's probably going to be the last. So, you want to make sure that your policies and procedures are reviewed by an attorney to make sure they're still legal. Make sure your signature cards are up to date. Officers and board members change every year. Make sure that every year you're going down to your bank to make sure your signature cards are up to date. Make sure that whomever becomes the new treasurer, they're physically getting the bank reports from the bank. You want to make sure that you're physically looking at the bank reports or the investor reports regarding your reserve accounts. The vast majority of managers, no, 99.9% of the professional managers out there are doing good work, but that doesn't mean that you trust. You always trust, but you verify. I learned that in the Navy many, many years ago. Trust but verify. Okay? Trust that your manager is giving you all the financial information you need. Once a year, go and verify it. I'd like to, that's been about an hour, so I'd like to say thank you for attending this Zoom presentation.